This week we are dealing with criminal procedure, but not criminal law. Okay, so as I've always been putting it clear that at LDC we have two procedure course units. Okay, the first one is civil procedure, which is done, and the second one is criminal procedure. So the question you need to ask yourself, do you know how the procedure moves? Okay, in your first term, you had a procedure of basically the magistrate court. Okay, so now ask yourself, this term you are dealing with the high court. So the presumption is you appreciated the procedure, how matters are dealt with up to trial in the magistrate's court. So this time around, you are going to deal with matters that are dealt with by the high court. So the presumption is, since this is a procedure course unit, you appreciate the procedure. Okay? So, should I do the lookup of the entire procedure? Oh, but we've been doing this. Okay? Yes? This is a procedure course unit. Okay? We can't go back to how to raise a complaint, accuse, suspect. Only that is repetitive. Okay? But however, as I told you, that criminal is summarized in how many words? 5. Okay? If you know how these words operate, you understand the entire criminal procedure. Okay? We said the first word is complainant. That is the person who initiates criminal proceedings. You can complain that Aisha did this and this, so you become a complainant. Okay? After complaining, Aisha will become a suspect who is being suspected of committing an offense. So at that point, you have to understand how a suspect is treated, how a suspect is brought to police, how a suspect records the statement, the rights of a suspect, okay, that this suspect enjoys. Then after Aisha is being suspected and police has done all that is required for investigations to take place, then if police finds that they have done sufficient investigations, then they will proceed and forward the file to the RSA for perusal and sanctioning. So that means once a charge has been laid to Aisha, she turns from a suspect into an accused person. So then ask yourself, if one becomes an accused, what are the rights that the accused person enjoys? The first right is the right to be presumed innocent. So that brings in application for bail. Okay? But before you go for bail, first ask yourself, are we dealing with a bailable offense? We have offenses that are not bailable. Okay? You look at the law. So that means when you are dealing with, first ask yourself, is the offense triable by the magistrate's court or the high court before you start anything? Okay? So when you are dealing with an offense that is triable by the magistrate's court, then after the person has, the charge has been laid against Aisha, then you proceed and take plea. So the plea this person takes determines the next step. So if Aisha takes a plea of guilty, you don't make an application for bail. That's the first condition. Someone who pleads guilty is not granted bail. Okay? So if Aisha takes a plea of not guilty, then you proceed and record the plea and then go for application for bail. Okay? Then if Aisha takes a plea of previous conviction, what do? Assume you are in Oros. They tell you that you are the sitting magistrate. The accused has taken a plea of previous conviction. Proceed. What do you do? That was first time. Okay, previous conviction. Okay, you are the sitting magistrate and the accused takes a plea of previous conviction. What do you do? Okay, you just remember when you take that plea, you have to adduce evidence of which suit. Okay, you give us the case number. So we write that very court that tried you, they give us the record of proceedings and mark this. There should that plea to stand. There should be a conviction or an acquittal. Okay, and a conviction happens either you've taken, okay, a plea of guilty, okay, and they convict you on your own plea. If not, okay, there was a trial. Okay, so now you ask yourself, okay, if not that plea, we have a plea of presidential pardon. That one we know how to deal with it. Okay, so now you ask yourself, after taking plea, what next? Okay, you go for bail. Once bail is granted, then depending on the type of the offense, is it a capital offense? Is it a misdemeanor or a felony? If it is a capital offense, we shall not proceed. Okay, you just come to court. Okay, we read for you the charges, and then you proceed to high court. Okay, so, but if it is not that type of offense, you will be tried in the magistrate's court. But as per your workshop now, all the offenses are capital offenses. So the first thing you need to do, your workshop has two offenses. I've not yet even looked at it, but I know it should be either murder and defilement or rape. Those are the two offenses they do this week. So the presumption is you have to read all capital offenses before the end of this week. All. If you have defilement, we expect you to read aggravated defilement, rape, okay, and all sexual related offenses or offenses relating to immorality by the end of this week. Okay, then if you have murder, you have to read all offenses related to infanticide. Okay, so the presumption is you're going to read murder, you're going to read manslaughter, you're going to read aggravated robbery as well, robbery. So all that line by the end of this week, you must have covered all of those, all capital offenses. Okay, so you sit and ask yourself, how ready are you? But now I know you are ready, not so? Yes. Okay, somehow. But anyway, just find the means. Okay, so as per this week, as I've said that your first term, you were essentially dealing with the magistrate's court. But this week, we are dealing with the high court. So whenever you get a workshop, first ask yourself, the subject matter I'm dealing with, which laws govern it? So you are dealing with criminal procedure. So which laws govern the content you are going to deal with? Okay? Which laws? We shall start with the most law, which is the Constitution. Then after the Constitution, we have to look at the, yes, the Penal Code Act. Then after the Penal Code, we have the Criminal Procedure Code Act, the MCA, and then the TIA. Okay? In my orals, the first branch I was asked that counsel, assume you are the sitting magistrate and the file is of murder. The prosecution has informed you that the investigations are done. Proceed as the magistrate. That was my question. Or proceed as a magistrate. So that means I had to remain sitting. When you stand up, you're not a magistrate. You lower the grade. You become counsel. Okay? So I had to remain seated. Then I do what we call committal proceedings. I commit this person to the High Court. Okay? And this is what you guys are dealing with this week. Okay? So now, after us looking at the laws, whenever you are dealing with criminal, okay, I know you still have issues with the perusal of a police file. Okay, that I'm very sure. Okay, the biggest problem that you guys are having, that is due. It's making you guys get worried of criminal. One, perusal of a record. Then two, evaluation of evidence. And if those two refuse, criminal muleke. Peacefully muleke. Because even if you are trying judgment, you're going to use evaluation of evidence. Even if you're writing a ruling in criminal, evaluation of, even if you're just perusing the file, it has a task of evaluating evidence. So if that one fails peacefully, forego the exam. Okay, but it will not refuse. So now let's get our file. I'm going to repeat perusal of a police file. Or for the second last time, I don't know, because you're going to be receiving these files until even in third term. But so the only challenge is in third term, the workshop multiplies this time is 2, because it has an appeal need. So they give you a record of proceedings, they give you the proceedings, they give you the judgment, so it becomes a bit huge. So if you didn't appreciate how to peruse this, now the other one will be more difficult than this. So I'm going to repeat this. Okay. So when you look at a police file, first ask yourself, you can't peruse something you don't understand. So first ask yourself, do you know how a police file is formed? Okay, that's the first thing. Do you know how a police file is formed? The components of a police file. Okay, why? Whatever statement is on a police file has a reason why it is there. There is a moment when you need each and every statement. So you can't just go on looking at each and every statement. So you read one statement at a go, knowing the reasons why I need it. Okay? So first ask yourself, what are the key statements on the police file? Okay? I'm not going to go back how it is formed. Okay? But for reason. Okay? What are the key statements? Yes? Yes? No. Okay, let's do it in order. I said I wasn't going to do it, but let me do it. Okay. Okay. So we say we have the following first. We have the complainant and suspect. Okay. When you understand this, you know how a police file is formed. So the first, this is what we call initiation of criminal proceedings. Criminal proceedings are initiated by way of a complaint. So what does that mean? The first person to go to police is the complainant. What does the complainant do? The complainant will record the complainant's statement. Everything starts with the complainant's statement. So when you get the police file like this, before even you do anything else, first look at the complainant's statement. Why? Your first issue in criminal, whether you like it or not, is okay, what offenses are disclosed by the facts. Okay, and when you are answering that, You only read one statement. Don't add on. Don't add on. Okay? Because it will complain. Okay? That Vincent did this and this. So that means if you want to know the offenses that are disclosed, are you going to read the suspect's statement? You get it? So the first major statement is a complainant's statement. Why? That's where everything starts from. Okay? So when you are perusing a police file, that is the file, that is the statement you shouldn't even miss. Okay? Then, as the complainant has complained, okay, you complain against who? A suspect. No, so you complain against a suspect. But before you get this suspect, okay, when you go to police and you raise a complaint, okay, under what circumstances can a person be arrested? Article 23. Yes? Unreasonable suspiciousness. Okay? That someone has or is about to commit. Not so? Who does the arrest? It's called the arresting. Now, have you ever seen files which have a statement of the arresting office? Yes? You will see it at the end. Because they bring files that are huge, yeah, to make you lose hope. Okay, why? Why do all after a suspect, a complainant complains, a suspect has to be arrested to be brought to? Now, why do you always have the arresting officer's statement, character before? Okay, character before and after committing the offense is relevant. Risk is tied. Section 4 and 5, 6 of the Evidence Act. Once you see that statement, just know you have circumstantial evidence somewhere in your facts. You get it? But at times, this may not be there. Okay? So if a suspect, a complainant complains, we have the complainant statement. After the complaint, the suspect will be arrested. We shall have the arresting officer's statement. After arresting the suspect is going to be brought to police. So the suspect is going to record which statement? The plain suspect's statement. How many statements are those now? 3. Okay? So once the suspect has recorded his statement, I've never seen a suspect's statement that agrees with the complainant's statement. Okay? We're not gonna you recorded that statement, it is rare. Okay? So as a result of that, the suspect's statement and the complainant are not going to be rhyming. Okay? But we want to dig deep to ascertain the truthfulness of the complaint. How do we do this? By way of searches. Okay? But why do we do searches? Okay? It is done in the bracket known as investigations. Who does the investigations? So that means after the searches, which is known as investigations, the person who has investigated, now this person knows the truth between the complainant and the suspect. So to bring the confusion to an end, we shall get another statement known as the investigating officer's statement. Okay? During the investigations, the investigating officer meets different people. Did you see what happened? You saw him coming, okay? Tell me. You become who? So that's what is called witness statements. You see, they come at the end. Okay? They come at the end. So when you are doing criminal, the issues in criminal are always standard. They've never changed and they'll never change. Yes, sir. Sin of crime. Sin of crime. I was just giving something brief so that before I say that let us go to this, people can easily draw a line when you say this statement so that you know where it is emanating from. Okay, so now, because if we had to dig deep in investigations, we could see what we call management of the crime scene, what we call a chain of evidence. But we can't dig about this time. Okay, that's why I have neglected the same. Okay, so you see, so what does this imply? The major statements on the police file are a complainant, and we know which issue is resolved by reading that statement. Okay, what offenses are disclosed by? That's one. Then after the offenses, okay, sometimes they can ask you, or is the next one is whether the file has sufficient evidence. Which statements do you use? You use the where do we get evidence from? The investigating officer's statement and then other statements. Okay. Then after that, they always ask you what defenses are available in the circumstances. Where do we get defenses? You read the suspect's statement only. But the challenge you people have, when you get to the ID, you want to read everything. Okay? You're going to take a lot of time. At the end of the day, you get confused. First, raise your issues. You know, these are the standard issues. Read the statement in line with something you are dealing with so that you deal with something at your own pace. Okay? Okay? So now, are we good to go to peruse now our file? So now I want us to peruse our file. So let's get our workshop. Okay. Now you ask me, say we are going to do the workshop first. We all know offenses. Okay, we all know the offenses. Then the way you wrote your workshop one at LBC, it is the same way you're going to answer question number one in the final exam. So it depends how you're going to be polishing. Okay, you saw the comment from Head Civil about raising issues. Okay, that it is a skill we attain with time. Okay, so don't get worried that attains the evaluation of evidence. No, things are going to work out. Okay, and we are working out there today and forever. Okay, yes. Okay, so let's go. Unlike other proceedings, we are not going to first read the law. Okay, yes, for reasons why everything you need, all the laws you need literally are here already. Okay, because you have to first understand the type of the offense. Okay, so let's read the learning outcomes. So just master the skill of summarizing this. I'm telling you, the final exam is huge of criminal. Me, I did an exam of 65 pages, but even reading the case of century of 45 pages is still a challenge. At your own pace for the entire year. Susan Chigula said, I'll show you that now. Okay. But imagine the examination paper is 65 pages. How are you going to make it at the end of it? It requires that extra skill that we are obtaining. Okay, so let's go to the learning outcomes. Learning outcome one says that by the end of the work, okay, so now when you realize that when you read your learning outcomes, they're using the word fathered. Why? You have already done this. So they want you to re-appreciate it. Okay? I told you the only thing that changes in criminal is one, the type of the offense and the type of evidence. So what does this imply? The reason why I want us to first read this, I want you to underline the type of evidence. And you get the Evidence Act, you read that type of evidence. Is it documentary? Okay. Is it expert opinion? Which expert? How do we tender in that type of evidence? That is the gist in criminal. The rest, they remain the same. Okay. So the only thing that changes is the type of evidence. Okay. Let's go. So, further, the ability to peruse a police file and identify possible offenses, disclose, and their ingredients. So let's start with that. Okay, so let's peruse our file. So the presumption is the issue we are having is whether the facts disclose any or what possible offenses are disclosed. So we are reading only that statement that is in line with that issue. Don't read any other statement until you get that issue. Okay? You'll see how life becomes simple. Okay? So the first statement we are reading is the complainant's statement. So when you're going orals and they ask you counsel, differentiate between institution of criminal charges and then initiation. Okay? You say criminal proceedings are initiated by way of a complaint. Okay? By a complainant. Okay? That's how we initiate. Then how do we institute? By laying a charge or by lodging a complaint to the magistrate. Okay? The presumption is to be mad. Okay? So we want to see which offense was initiated. Okay? It says that Uganda police. Okay? What is police form to be? Yes? What is police form to be? Okay, so the statement give up a number. Please write them. At least minimum quarter 7 or 8. Go join police form 2-3, police form 23, police form 24, police form 25, police form 48, police form 50. And at least you can just say you'll enter in orals, they ask for 10, at least give 8. Because you have these documents. You draft charge sheets, you draft indictments, those numbers, but you joke with the backwards. Okay, so let's go. Okay, full name Ziwa J, occupation police officer, nationality Muganda, place of local residence Chila Police Barracks. It says that the above particulars and address are true and correct. I do wish to state that the day of 10th February 2022 at around 9 hours. So let's underline 9. Underline 9 hours. Why? What time is that? Okay. Yes, what is the time? Is it 9? Is it 9 a.m., 9 p.m.? You know, the effect of time, that's why I've paused there. The effect of time in a criminal is very critical. That's why I'm asking, what time is this? Is it during the day or during the night? Yes? Oh, okay. Let's go. I reported for duty at Kira Road Police Station and was informed that one suspect by names of Chiwa Yusuf was rushed to Murago Hospital. I asked what happened to him and was told by the officers at the counter that she had been assaulted by suspects in cells. Underline, had been assaulted by suspects in cells, and he was unconscious and rushed to hospital. I called the person who took him, and he informed me that the man is in critical condition. I decided to take action against the suspects who had done this thing. I called the RP to tell me what had happened. He informed me two names, Jali Eli and Indiga Eric. The two were on charges of assault and were rearrested and detained pending further inquiries. The RP gave me the iron bar that the suspects used. Underline the iron bar that the suspects used to assault the deceased. Underline deceased. Underline deceased. Okay? Socket command. Why did they start that the guy was rushed to the hospital and he was in a critical condition? He had not, but at the end of the day, he died. But the challenge is they are not telling us when he died. Okay? So have you ever heard of a principle of possession? Yes. Okay? What amounts to death? However, okay, it's 1 year and 1 day. So put that into consideration. Okay? It may not be in these facts, but it comes back in the idea. Okay? This guy dies fast, 1 year and 1 day. You charge them murder. You charge them murder. Okay? Because past that time, you can't charge this person murder. Okay? You look for other charges, maybe, but not. So whenever they give that someone that was sick and eventually fell sick, they are looking at the principle of possession, that he died as a result of. Let's go on. Okay? And I handed it over to the investigating officer. They pulled this back from the window of one of the cells. This is all I can state and self-recorded. What happened at police? Which offense? Yes? Which offense? Can someone say which offense? Sure. Did this person die? Yes, but did this person die? Why did he die? So, have you ever read on the principle of possession? What caused his death? So, what offense was committed? Okay. Now, you as the RSA, okay? Cancel what offense? Good. Okay, cancel which offense? Cancel saying murder. Now, when you read your workshop, it says offenses disclosed by. So how many offenses have we seen? 2. So now, but we are not certain whether, so when you are answering issue 1, you know you don't need to write. Okay? We don't know whether the offenses can sustain. Okay? You get it? We are not certain whether we are just identifying. Okay? So whenever they tell you identify, now what really hurts your PAs? They have told you identify.
You
Okay?
explain.
You explain. Now they ask yourself, do really these guys understand what to do? They just tell you identify. So in identification, you just say, you just write the principle of legality. You define an offense and say, in the instant case, the facts disclose the following offenses. 1, murder, contrary to section 188. Then 2, assault occasioning death, contrary to this. The issue is done. But for you, you want to go ahead and explain ingredients from there. Now, what are you going to do on issue 2? Simple as that. It is done. Will you read only one statement and stop there? Only one. Okay? But okay. But for you've seen how you've been reading the file. An exam is different. I'm telling you. Okay? You see the IAs. I said you've not yet mastered the art of finishing the IA. It's going to take you some time. Okay? And remember it is counting. So now imagine the framework.
Yes.
How things will be. Yes. Offenses that you have murder and then assault. Okay. Just identify and pick that. Okay. What talks about assault occasioning death? Okay, but it can be just plain assault. Okay, because no, but we shall tell. But the offense will be assault occasioning actual bodily, but we shall see. Depend. Yes, that's why we have murder as well. Okay, but we shall tell. After looking at the evidence on record, we should be having the postmortem reports. Okay, so we go on. So let's go back to our learning outcomes. Yes, answer. Yes. RP. It's a police officer in charge of sales. Yes, it's an office of the sale. When you are arrested, yaba officer wakafaako akubuuza olinamu mmeka oyagala tuula mu nsonda oba wano. It's the RP. Okay, it's the RP. Okay, yes. So
I don't think.
Let's proceed. So let's go back to our second learning outcome. Okay. Yes. Yes.
He's coming.
Okay. So learning outcome 2, to further the skill of critically analyzing and evaluating evidence assembled in homicide cases. So now, let me tell you, once you see the word homicide, okay, once you see the word homicide, make sure you don't go for assault. Don't even waste time. Okay? Is it under homicide? So that means you only have murder. So drop assault automatically. Don't waste time. Okay? LDC has answers everywhere. Okay? So we go on. So now, when we're together, It is okay. But before I leave this place, I have to make sure that everyone can evaluate evidence. Okay? That's the first thing. So let's get the penal code. The issue of evaluation is framed that whether there is sufficient evidence to sustain the proposed charges. Okay? Whether there is sufficient evidence to sustain the proposed charges. Okay? Whether there is sufficient evidence to sustain the proposed charges. Okay? So now, so before when we start reading, what does it take for you to evaluate it? Okay? After you've identified the offense, you first go to the section. Before you start evaluating, you first go to the section that provides for that offense. Why? You have to first outline the ingredients. So if you deal with ingredient by ingredient. So let's get the penal code. We read the law relating to murder. Okay? So, and when you are evaluating evidence, you associate yourself with the following words. Okay? We have proof, we have corroborated, and then confirmed. That means when you are evaluating evidence, you should make sure you read 3 statements. The first statement will prove, remember the law regarding evidence. We have evidence that requires collaboration. Okay? Then you go and collaborate. Okay? After collaborating, please confirm with something that confirms committing that offense. Okay? Okay? This one sometimes it's subtle. Okay? Okay? So this is how we're going to be moving. So let's get the penal code. We first read, we put the ingredients aside. Okay? Then we start evaluating our evidence. You guys need me to go through the principles of evidence as well. Okay? Okay? But it's okay, we shall start doing it. Okay? So, Aisha, take us through. Yes? It's okay, I'm going to do with it.
Section 188.
Yes, section 188.
Murder.
Are you guys on? Oh, she has to project a little bit. Find the project. Actually, you can stand. You have to shine. Everything doesn't end here till this. Yes. Let's go on.
Section 188. Murder. Any person.
So first stop there. That any person. Okay? That any person. What ingredient is there? Any person. Okay? That is participation. So the killing should be done by any person. A dog can't kill. Okay? You guys, yes. Now, did you guys, you did? Okay, let's go on. Proceed.
Any person who of malice aforethought.
So the second ingredient is malice aforethought. Okay. Then another one.
Causes the death of another person.
So another ingredient is causing of death. Okay.
By
Then the last one, that the death should be unlawful. So those are the ingredients of murder. So now, after understanding the ingredients, you come back. You start evaluating. Is there any of the above ingredients that you may not be able to satisfy by this file? Okay. So now, when you are resolving that issue, how do you start? Okay. You start with what we call the principles of evidence. And we know these principles are two. The first one is burden, then standards. Okay. Burden and standards. Council, take us to section 101 of the Evidence Act. Section 101 of the Evidence Act. Okay. We are first reading that. Okay. Now we are just first reading the different provisions, then we align it very well. Okay. Burden of proof.
Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he or she asserts must prove that those facts exist.
Okay. So when you look at section 101, who asserts? So who asserts in this matter? The prosecution. So what does that imply? The burden lies on the prosecution. Okay. Then we need to look at 102 as well.
Yes.
Because it literally has the same wording. Okay. Let's read also 102.
102. On whom burden of proof lies. The burden of proof in a suit or proceeding lies on that person who would file if no evidence at all were given on either side.
So now, if the prosecution asserts that I killed and it fails to adduce evidence, will I lose or it will lose? So it seems like the same meaning. So what does that imply? So the first principle we deal with is the principle of burden. Okay. Now, after burden, which second principle do you deal with? Standards. Okay. Standards. Okay. Now, whether you know or you don't know, just close your eyes. You think of any criminal case, at least you cite it. There is no criminal case where those two principles are not there. About money, please write. Okay. Whether you just add it by osmosis. Okay. You say Uganda versus
Russia.
It's okay. Uganda versus Katoka Jubi. It is okay. Uganda versus Robert Chagulanyi. Uganda. Just think of any case which has Uganda. Okay. Now, to be honest. Okay, let's get back. So you get it. Why would you waste your time? You scratching your head thinking of the case. Okay, you've been seeing Kanyamu on TV. You saw where I'm saying it, and you failed to get the case with burden and standard, and you keep on citing the English cases. When will you go there? Okay, so you think our judges here, they make that students for no reason? No. Okay, and it is not fatal. Okay, it's not fatal. We have cases done by senior counsel Henry Kunya. Cite them to also feel happy. Okay, but when you keep citing the case of Mira versus Minister of Pensions, who saw him? Okay, hey, so use our Ugandan cases. So now, how do we arrange these two principles? Okay, Members, let's get back, okay? So when you are dealing with that issue, these two principles should be into your mind. But how do we arrange them? The general rule is under Article 20. Remember now this person is an accused person. We said the rights of an accused person has a right to be presumed innocent. So the first thing, even before you start writing the Fahrenheit standard, you first write about the presumption of innocence. Okay? That every person is presumed to be innocent until proved guilty or okay. So now after that, now you have to show us who has the duty to prove. In case this person doesn't plead guilty, who has the duty? Then you go to what you call, you go to the burden of proof. Then you show us who has the burden. That's when you go to court 101 and 102. Then you attach any famous case, okay, that is deemed necessary. Okay, it is okay. Okay, then after that, you go to the second principle known as standard. You also, that one has no provision in the law. Okay, does it have a direct provision in the law? Just case law. Simple as that. Okay, so now after that, you start by laying the ingredients. So after giving us those principles, then you say Section 188 of the Penal Code states the ingredients of the offense of murder. You list them. Okay? Then again, you don't waste time. You pick any of the cases you've cited above. You say, in the case of Uganda versus Katoka Jubi, court held that for any person to be convicted of the offense of murder, the prosecution should prove all the ingredients as laid down under Section 188. Then you start ingredient 1. Okay? But it is prudent, the last ingredient should be participation. That is the best. Okay? Why? Just know if participation isn't proved, the rest we call a proof. It is tagist. So when you start with it and it's not proved, overall ago, you get it. Okay? So because obviously, how do we prove the existence of a corpse? Death is there automatically. You can't tell me that you know what amounts to legal killing. Okay? The killing wasn't legal automatically. Okay? So the rest you can survive. But don't start with participation. It is hard to prove. So don't start with it. You lose hope for no good reason. Okay? So let's start with the first one. Okay? So that's the first ingredient. Leave participation of any person. Then we start with which was our second ingredient. Malice, aforethought. Okay? Malice, aforethought. The law has defined what amounts to malice, aforethought. Whenever you have a section that defines that, first start with it. Okay? So when it comes to malice, aforethought, the penal code defined malice, aforethought. Non-stop. So which law? Just of this in which section? Okay. Section 191 of the penal code. Okay. Council, take us through 191. Yes. Members, be reading.
Malice, aforethought. 191.
Section 191 of the penal code.
Malice aforethought shall be deemed to be established by evidence, providing either of the following circumstances: A, an intention to cause the death of any person, whether such person is a person actually killed or not. Or B, knowledge that the act or omission causing death will probably cause the death of some person, whether such person is a person actually killed or not, although such knowledge is accompanied by indifference, whether death is caused or not, or by a wish that it may not be caused.
Okay, so you see, so when you look at 191, it's very clear that malice aforethought is the intention to cause death. Whether the person you intended to kill is that person, but provided you have killed, you had an intention to kill. That is what we want. So it doesn't matter whether you killed Rashid or Vincent, okay? Because you know, I have circumstances where sometimes it's say Rashid, you know. So that day Rashid goes out. So Vincent sleeps over Rashid's place. So you come, he starts slaughtering Vincent. Okay? Your intention was to. So whether you killed Rashid or not doesn't matter, provided you had the intention. But your facts at times may not be falling in this. So we have circumstances where malice will be there, but not in relation to this act. Okay? We have case law that gives circumstances under which you can tell that someone had malice aforethought. Okay? Which case is that? And please mark this. Okay, 95% of the murder cases and the persons detained in upper prison are women killing their husbands. Use that information accordingly. Okay? Okay. So now we have a case. It is of one of the famous women, okay, where a court held that malice aforethought can be seen according to one, the weapon used, two, the place you've injured, okay, the place you've targeted, okay. If I shoot her in the leg, okay, and I shoot her in the head, those two things are different. So okay, but someone who shoots in the leg, that person has no malice. Now, if shooters don't miss, okay, you get it. So, which case is that? Who has ever that case of Susan Chibula? Very well. Yes, at night, but did you read it very well?
Yeah, I watched Town.
So, get time and read. Yes, guys. But as that matter come to an end. Okay, so you look at that decision, okay, it also has the same element. When Justice Kawesa was deciding that case, he elaborated what amounts to malice aforethought. Why? Yes, okay, it is Desire versus Matthew, the great Chiravo. Okay. Yes. Okay. No, it is Uganda versus Matthew Chiravo, but it is commonly known as Desire Mirembe. Okay. Okay. Others say boyfriend. Yes, that Mukono case, okay, where the guy killed the girlfriend who was aspiring to be a doctor, okay. But when you look at how he killed. Okay, it really shows that the guy had malice aforethought. Omanyinga tewali yadde hope of this girl surviving at all. Namupakinga nomupakinga. Yeah. You can also read the case of Uganda versus Akibar Godi. Okay. Uganda versus Akibar Godi. Okay. Akibar Godi. Also, that case explains malice aforethought. When you read that case, for them now they use what we call character, after and before. Okay, so don't only base on section 91. So the facts you have may be able to give you other circumstances that draw an inference to having malice aforethought. So don't restrict yourself to only section 91. Okay, so I would get, okay, it is Uganda versus Matthew Chirapo. Okay, so I would get send off. Hurry up, disorganized that. Okay.
You've not hugged him.
Okay, so let's get back colleagues. Okay, so at least read those cases. Okay, you will be able to tell. Okay, we go on. So now, after reading what amounts to malice aforethought, okay, and then you've read, okay, you've read the any of the cases we've cited, then come to your facts. Okay, you see the factors that are considered. Do I have them in my facts? Okay, so when you read the case of Uganda versus Matthew Kirao, okay, how did this guy kill? What did he use? Yes, counsel, what did he use? Yes. But when you look at the place where he slaughtered, yabala emisuwa gino, waliwo omusuwa gwe bakusala n'owona. Okay, yagibala n'asala direct ogenda ku bwongo nga bw'ogusala tosobola kumala na ddakiika eziba oli mulamu. So bwe yasala bw'ati. Yes, yakozesa surgical blades n'amusala yasala busazi musuwa gwawa ddakiika ezi n'amupaakinga. Why? Okay, yali tasobola kusala ku mukono. Okay, so now you come to our facts, okay, and see how are we going to impute malice aforethought. So let's get back. Okay, members, let's come back. Let's come back. Yes. Let's get back, guys. Okay, so now members, let's get back. Okay, we are on this one now. Okay, we want to prove, then we collaborate, and then confirm. Okay, so we start with the first one. So we want to prove that this person has had malice aforethought. Okay, so now which statement has evidence? Which is the key statement in evidence? The investigating officers, because this person did the investigations, he's going to recover some of the things. Okay, so now, was the complainant a police officer or not? So start with that. What did this person use to kill? Okay. Okay. Why? I'm going to read a certain statement. You will tell me. He said that I called the RP to tell me what happened. He mentioned two names, Jelly and Ellie. and Indiga Eric. The two were on charges of assault and were rearrested. Hold on. So use the iron bar. Okay, okay. The RP gave me the iron bar that the suspects used to assault the deceased, and I handed it over to the investigating officer. Underline the second word. After there, they pulled this bar from the window of one of the cells. Imagine, omuntu watuukira okujjamu iron bar aba agenda kuwa kyali. You see, ng'alaba byalina tebikola ki tebimumala. You get it? Okay? Yes, guys. We shall get there. We shall get there, guys. Okay? So now, from that, okay, remember up, you quoted the case of Uganda versus Matthew Chirago, where Justice Kawe said that in referring whether someone had malice aforethought, critical analysis should be made one to the object used. Look at the object. You see? So now, after that, you say this is proved, okay, by the complainant's statement, paragraph 1. Count the lines. You tell me it is on which line. Okay. Okay. So count the lines. You get to that line where that statement is. Yes. Okay. We've said we are proving. Okay. Or supported. You get it? That this person had malice. So we shall say, you've already given us the case of Justice Kawesi. Okay, that is Uganda versus Matthew Chirago. So now you want to support that position using evidence on record. So you said this is proved by the complainant's statement. Okay, paragraph 1, line 13, where he stated that. Okay, the RP gave me the iron bar the suspects used to assault the deceased. They pulled this bar from the window of one of the cells. Okay, so you get. Now we want to still further confirm. So now we want to collaborate. So you get another statement that shows that this guy had the intention to. But now we don't know where they hit him. Okay, okay, because someone who hits you in certain parts, they should so let's go on. So you turn. Okay, look for another statement. Go to the investigating officer's statement. That one collaborates. Okay. So now let's read there. We go on. Are we still at the same page? I know Friday was the speed, yeah, but it is okay. Okay. It says, on that day I received a case file of murder of one Chiwa Yusuf by fellow took place in police cells. Two witnesses made statements. So underline two witnesses. What does that imply? Basolo kuwa statements, isn't it? The political witness statement here. We always have areas that require further whatever the IO mentions should be on the file. So that's why I've got underline 2. So that means we shall go back and ascertain how many witness statements we have. Every name he's going to point here should appear somewhere. Okay, so we go on. Made statements in regards to the incident. I was handed the iron bar the suspects used and marked and exhibited it. I immediately filed that booked out to KCCA, Mortuary Mulago, in company of the friends of the late Chiwa. On arrival, I introduced myself to the mortuary staff and the reason for our visit. We were taken inside and the friend of the late identified his body. I then handed over PF 48A and B requesting for postmortem to be carried out. The details were registered and I was handed over a carbon copy of that, with which I returned to police. I then took the suspects, Eric and Ellie, for medical examination. After filing those forms, and I took them to Market Street Clinic, Nakawa, where they were examined on that form, and we took them back to Chira Road police cells. Both suspects were found normal and of sound mind. Underlying that, what does that mean? But their mental status was then to come. Okay, you see how we are collaborating now. You say this is collaborated by the investigating officer's statement. Paragraph 1. Which line is that? You can say the last line where he stated that. Okay, we took the suspects for medical examination where we found that they were normal and of sound mind. Kitegeeza kye baali bakola ki bakitegeera. So that means we don't expect to raise a certain defense at a given time. Okay, so now we want to confirm that these guys had malice aforethought. They have told you here that a postmortem report was made. So first go and look at the postmortem report. You get it, so that you see which parts were dealt with. Okay. 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 So go to page 16. That's where the postmortem report starts from. Okay. Okay. So I want us to just go where we see findings. Are we there? Yes. Is that? Yes, but that we collaborated. Yeah, those medical reports, they confirm the position of because some statement they are investigating office. Okay, so let's read the findings. Council read the findings. Council is reading. Dressed in black pair of flesh shorts only. There was an abrasion on the left shoulder joint. Joint at page 17. Okay. Measuring 5.0 to 2 centimeters. the scalp and a skull were intact, but had a massive
subdural hematoma on the left side.
weighing that, pushing the brain to the right side and therefore causing compression of the right cerebral hemisphere. What does this mean? This guy was hit at the head. Okay, so what does that indicate? If okay, so then you say this is confirmed by the postmortem report, paragraph of findings, where Dr. Wawire Stephen stated that you quote where he stated that this guy's brains were damaged. Just quote that statement. What does that? So he said this indicates that the suspects, okay, targeting the head of the deceased, being that they were in their right mental state, they had malice aforethought. You see, you proved, collaborated, and then confirmed. Those are the three. So each ingredient you should have to look for three statements to use. Okay? Is it hard? Yes. Yeah, even the cause of death, it is fed. So this guys, that's so when again you go back to the same case, this guy he cut the neck in the Chirago case. Okay? But single spare. You see? So the place where you target shows malice aforethought. So, haven't you proved the first ingredient? Very simple. Okay. So, we go to the second ingredient. Should we cross to another ingredient? Or what will we do? So, let's go from there. Okay. Let's go on. Okay. So, so what is our second ingredient? Okay. Causing of the death. Okay. Causing of. Now, okay. What you should know, okay, that as I told you, over money, we don't have, okay, any law that defines that. What you have any law that defines causing death? Are you sure? Huh? Are you sure? Yes. So now you just quote any of the cases you know on murder. Okay, you can use the same case. You can say in Uganda versus Matthew Kirabo, court held that for any person to be convicted of murder, the prosecution has to prove death of the accused by adducing one, the dead body. Okay, the prosecution should prove, okay, should prove the death by one, adducing proof of the dead body. Okay, then two, the first one by proving
Who's there?
dead body.
Who's in
Then
the bathroom?
by use of, how do you prove? By use of a postmortem report. Okay, so now we come back. We have to start, we prove, we collaborate, and then confirm. So what? But we confirm when you are confirming actual death. We confirm by a postmortem report because it is the final document on death. Okay, but we prove by words. Nasanga akozechi afudde. Then we collaborate. We went to the mortuary. Simanyi wabano nayo mulamu. Okay, you see. Then you confirm. Truth twasanga akozechi. Result we got is simple as that. Yes. Then read section. Have you ever read the law known as the Missing Persons Act? Okay. Read the Missing Persons Act. You read section 2, defines presumption of death and the missing person. Then you go to around section 24, 25. The answer is there. We are going to do it. We are going to do it. So let us start. Okay. We want to prove that there was death. Not so. Where are we starting from? Complainant. Okay. Everything starts with the complainant. That's the technique. Okay. We read the complainant's statement. Not so. Should we need to quote it again? Okay. Criminal mwangu. Okuandika kunje. Okay. So here we say that. Okay. This is proved by the complainant's statement where, okay, paragraph 1, line 13, where he stated that the RP gave me the ionic bar the suspect used to assault the deceased. You stop there. Okay. So, whom do we call the deceased? So now we've proved that now this person is no longer unconscious, but is totally dead. But we have to collaborate this. How? Okay. We go on. We say, okay, this is corroborated. This is corroborated by witness statements. Okay, this is corroborated by witness. So you have liberty to choose. So which witness statement number is this? We have 1, 2, 3. Okay, so you can choose any because you see at the end they all say I came to learn that he passed on. You get it? Okay, so you can choose any website. Okay, you can say this is corroborated by witness statement number 4 of, okay, of Agava Elvis, paragraph 1, the last line, where he stated that I came to learn later that he passed on. Okay, so this one is corroborating the first one. So you can choose any of those statements. Okay, but as of now, okay, so let's go on. Okay, as of now, when you look at these statements, okay, which statement carries more weight? Okay, so which carries more weight? We have the IO, we have even the witness statement. Also, you can decide to run with the IO statement. Then you say, this is corroborated. This is corroborated by the investigating officer's statement, paragraph 1. You calculate the line and say that I went to the mortuary in company of friends of the late Shiwa, and on arrival, I introduced myself to the mortuary staff and reason of our visit. We were taken inside, and the friend identified the late, okay, the investigating officer. They went to the mortuary, and the friend, yes, with a friend of the deceased, okay, who identified the deceased's body. Okay, you see, are we together? Okay, so now we prove, we corroborated, then we confirm. We need to know, to get now they confirm. We said this is confirmed by the post-mortem report of Dr. So and so, where he stated that, okay, the cause of death was injury, head injury following blunt force trauma injuries. That means the guy died. Okay, simple as that. Okay, so things are simple. Okay, so things are simple. So, our colleagues, let us borrow 8 minutes of your time. Okay, we first first go for prayers and we come back. Inshallah.
Really? Consolidated
Okay, so far proved how many ingredients? Okay, so prove the 2 ingredients. So we're going on our third ingredient. The third ingredient is that death is unlawful, or death was unlawfully caused. Okay, our next ingredient is that death was unlawfully caused. Death was unlawfully caused. Okay. When you read the case of Wellington versus DPP, define what amounts to unlawful cause of death. Okay. Who has ever read that case? Are you sure? Are you sure? Huh? We have what we call actual reading and reading by osmosis, and then reading by hearsay. Okay, so can so be specific. Which reading of the 3? Okay, shall tell. Shall tell. Okay, so when you read that case, Mr. Lord Denning, in his wording, stated that death will be referred to as unlawful death when the means of death are not authorized under the law. Okay, when you read the case of Wellington versus DPP, okay, Lord Denning, in his judgment, stated that death will be referred to as unlawful death. Death will be referred to as unlawful death when it is caused by means that are not authorized under the law. when it is caused in means not authorized under the law. Okay. Okay. So now, when you read our Ugandan case, okay, when you read Uganda versus Katoka Jubi, read Uganda versus Susan Chigula, but the case that really expounds that principle is Uganda versus Dr. Abre Kiyingi. Okay, in that case, court held that the ways, the authorized mode of killing in Uganda are one, execution. Okay, one, execution. The authorized ways of causing death are execution, okay, of a death sentence. Same was held in the case of Uganda versus Susan Chigula. Okay, that's the first mode. Kati gwe weebuuze client wo yali alina gw'ateeka kalabba mu police cell. Okay, then another one. Okay, we said the first one is execution of a death sentence, the first authorized mode of causing death. Okay, execution of a death sentence. Okay, then another one, natural death. Any other death other than witchcraft, provided it's not caused by some other person. Okay, but by witchcraft was authorized in Uganda. We had the Witchcraft Act, but it was repealed. The challenge is they had no judge. Okay, it is still operates.
2 years ago,
Since she's an expert, we shall discuss cancel details. Okay, so we go on. Then another one, but these ones, the law authorizes them, but in most cases, they don't go into murder, they turn the offense into manslaughter. Okay, one, self-defense. Okay, where you cause death of someone during self-defense. That one is okay, it's understandable. Okay, don't you know? Okay, then another one, death on provocation. Okay, defense on death on provocation. Okay, then another one, necessity. Necessity, use the case of Jereketa. Okay, to explain the principle of necessity. Jereketa, ever heard of it? The guy who has amputated the leg, the guy had cancer. He's called Nzit Jereketa versus Northern Borough Council Hospital. Okay, Jereketa case. That guy had cancer. Okay, so the only way to save him was to amputate his leg. So by the time they brought him to hospital, the guy was unconscious. All the relatives disappeared. Okay, so the doctor said to stop cancer from spreading and to save this guy, let us amputate him. So after the full getting medication, and he gained his sanity, and he realized that cancer had disappeared, he sued the hospitals for unlawful treatment. They said, no, that was trespass to persons. Okay, you guys amputated my leg without my consent. So they raised the defense of necessity. So that defense of necessity was explained. So when you look at infanticide, okay, Some people have a question: is abortion authorized under the law or not? Okay, it is authorized where it is a necessity. Okay,
Northern Borough Council Hospital.
this is Jerikita versus Northern Borough Council Hospital. Okay, so when the killing is in those ways, the law has hint on them. But where it is outside that, that means the death is caused by unlawful. So now we want to prove that the death was caused by unlawful, means then we collaborate and then confirm. Okay, so we start. Now this time round, the investigating officer's statement can't start. Was he there when the death was taking place? He came after. Section 59. Evidence is given by the person who saw, who had, or who. So now, where do we start from? Yes? Where do we start? We start with the witness statements. The witnesses were in the cell where the saga happened. So you choose which witness for a series of answer. Okay. Which one? Okay. We are handling that death was unlawful. So which statement cancel? We have the one on page 6. Okay. It says it is a Agaba Elvis, a border rider. It says I am done above it. It is we have Male Matayo. Okay. Male Matayo, which says that I am of the above address and particulars. I do wish to state that I was arrested. So what does that mean? This guy was in, he saw what happened. Okay, that I was arrested from Bukoto on the case of theft, which I have been detained for. I was on that date when my fellow inmate by the names of Chiwaiso was in cells, but was disturbing other fellow suspects because he wanted cigarettes. In that process, he assaulted another suspect by names of Jali L. So Eli also fought him. Eli got an iron bar which was lying in the toilet and hit Chiwa on the chest several times. Oh. We tried to separate them, but instead, Eli was joined by Eric, and he also started beating Chiwa randomly all over his body. When I saw that we were failing to separate them, I went and called the RP to help. They continued to beat Chiwa until he vomited blood and fell down unconscious, and they continued to sleep on him, so, to step on him so that he also feels it. The RP called their family, and later the patrol came and took Chiwa to the hospital. Okay, so what do we want from here? Is this beating authorized? Okay, so why are we using this statement? We are following the principle of causation. What caused the death? Okay, so what caused the death? The random beatings. Okay, the random beatings. Okay, so we shall say this is proved by the witness statement of Malice, okay, where he stated that Ellie fought him. Ellie got the iron bar which was lying on the toilet and hit Chiwa on the chest several times. Imagine, just think of someone hitting you on the chest several times. Just think about it only. It will be sufficient for you to tell what he went through. Okay? And then after, imagine someone after beating you, they sit on you. Okay? And you see what happens. Okay? Okay? So now we want to collaborate this. Okay? We want to collaborate this. Which statement is fit for collaboration? Yes? Which statement is fit for? Yes? So we said this is collaborated. This is collaborated. This is corroborated by witness statement of Agaba Elvis. So we are going to read it, okay? Because it corroborates. It says, I am the bearer of the above particulars and address. I wish to state on the incidents that happened here at Sherwood Police Station that I was on that day around that hours. Chiwa started stepping on his colleagues who were sleeping and a fight started. I remember someone came and called me that there was a fight in their room. I hurried to the room only to find Ellie and Eric seriously beaten. I particularly saw Ellie with an iron bar beating him on the head and the chest. Oh, what man. Okay? So you see, this is corroborated by this statement, paragraph 1. You count the line and say where he stated that I particularly saw Ellie with the iron bar beating him on the head and the chest severely. Okay? Then you said he further stated that I came to learn later that he passed on. Okay? So now confirm. What confirms that the death was unlawful? You got the postmortem reports. What does it say? So, because you just got cause of death only. Okay? We go to the postmortem report. We said this is confirmed by the postmortem report of Dr. Wawere Stephen, where he stated that the cause of death and reason for the same head injury following blunt force trauma injuries. Okay, is that a natural death? So what does that imply? Then you conclude that I find that there is sufficient evidence to prove the ingredient that death was caused by unlawful means. Okay, so now let's go to the last and pertinent issue: participation. Okay, hey yo, participation. You just said that because you are the RSA, you said that I find that there is sufficient evidence to prove the ingredient of cause, unlawful cause of death. Okay, so we are looking at the last ingredient of participation. 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 Okay, we go on. So when you are dealing with participation, which section do you start with? When you're discussing participation. Brenda, which section do you start with? Yes? Which section? Yes? Yes? Cassandra, which section? The penal code. Participation. That one is an offense. Okay. Definition. Does it define participation? No. Let's go to section 19. Okay. Section 19 of the Penal Code Act. So whenever you are dealing with participation, you first look at section 19. What does it say? Why? Who commits an offense is the offender. So we want to see, according to our facts, who and who participated. Okay? So let's first read section 19. Okay? Shall be charged, okay, shall be deemed to have
taken part in committing the offense and to be guilty of the offense and may be charged with actual committing it.
So now we want to see, okay, the people we have, they fall under what category? So when you look at that section, we shall read it further. It has what we call a principal offender, the person who does the actual act of killing. Okay, Ganze Nakatuga. Okay, did you read the facts of Susan Chikula very well? How she slaughtered the husband with the maid. Okay, the maid, they sent the maid to buy the panga 1 month back and she had to keep it. Okay, okay, then the day the guy came back after some long time without being home, he entered the bedroom and said to West Cocarito. Yeah, they just came behind with a pang and slaughtered him. When the son was seen of 6 years, because Madame left the door slightly open of the sitting room. So remember, the sitting room was just adjacent the bedroom, so she forgot to close the door. So those two committed the offense, but after the maid, or how did the maid disappear, I don't know. Because when you read the case, the maid is nowhere, but the maid was there. I don't know how she decided. She turned into a witness. Yes.
YouTube, that chocolate lady cries like she claims she's not the one who killed her.
Why? Okay. She was possessed. Okay. Again, no. You see, so when you look at that actual, okay, when you look at also the facts of Werasing, how it happened, okay, she first told the maids to go, the maid went, the askari also went. After some time, then she told the husband, maybe get. Okay. Then after opening like this, so she made a mistake. Naddako n'emabega n'amufotola bulungi akakasente amusi. Okay? You see, she's the person who actually committed there. So when you are reading participation, look at those categories under that section. We have a principal offender, we have accessories before and after. Okay? Accessories before, those guys who help you to prepare committing the offense. Okay? Then after, these people who hide you after committing the offense. Okay? I don't know. You see? So when you are reading our facts, we start with that section. So the presumption is we have read it. Okay? Then after that, you quote the case of Uganda versus Katoka. It is Katoka versus Uganda, they appeal. It is, the appeal is also Uganda versus Katoka. Because remember, he was first acquitted. and non-DPP appeals. That is one of the hardest things I've ever seen. Hard fire. Okay? So when you read the appeal, court held that the most pertinent ingredient in criminal offenses is participation. Failure of the prosecution to prove participation of the accused, it leads to an acquittal. Ziri endala zisobola okugaana. Okay? They will just reduce the punishment. But once you fail to prove participation, it is automatically an acquittal. Okay? It is Uganda versus Katoka. The appeal, the challenge is that case. Both are Uganda versus Katoka. The appeal and the first case in the court of first instance. They both have Uganda versus Katoka. Okay? But that holding was in the appeal case. Okay? So, yes? Okay, court held that the most pertinent ingredient in all criminal offenses is participation. Failure of the prosecution to prove participation, it leads to an acquittal. Okay? But then read that case of Katoka. Because the first charge sheet, it was Uganda versus Katoka and another. The witch doctor. But now, I don't know. Again, after the witch doctor disappeared and became a witness. Yes, the guy became a witness in the matter. Yet he was an accused person. I remember. Okay? Yes. Okay, that is criminal law. We don't know why. Okay, so now after reading that, we also have a case of Uganda versus Okelo, but no, we use that. Okay, so then after that, now you come to our facts. We want to prove participation. Okay, we want to prove, but remember, this is not direct cause of death. You get it? That he was hit and he died there, and no, this guy was first taken to. So now, which case talks about possession? The first place. Okay, which case talks about possession? Did you read Uganda versus Kanyamunyu? Yeah? Did Kanyamunyu die there and then? When the guy he shot, did that guy die there and then? Remember, after shooting him, Kanyamunyu, out of fear, and the wife, they carried him. They rushed to Mulamu. Okay? Then stupidly, and eventually the guy died. But when we read the postmortem report, it shows that he died as a result of the injuries sustained from the shooting due to overbleeding. So that's why when you use the principle of possession, that's how this guy was held liable. Okay? Because the result of this guy's case was caused as the actions of. So come to our case. Okay? So we want now to prove participation. Okay. So which one are we using to prove? Can you get how it flows? Which statement are we using to prove? That one, the medical report and the IO, they will confirm. Okay? Look at the witness statements. You choose any of these guys who are in the cell. You choose any. Okay? You choose any. Then after, what is going to corroborate? The officers who took him to the hospital. Then you confirm using which statement? The IO, and then we haven't proved because we had already read those statements. Okay, but I'm just showing how you add in. We are going to say this is proved by witness statement number 3 of Agaba, where he stated that, okay, I saw Ellie and Eric beating the iron bar and hit him until he started bleeding, vomiting blood. Okay, yes, guys. That one, so that one, yes, you confirm that yesterday. Okay, I will get it. Okay, so we shall start with that statement where this guy says they hit him on the chest and the head until he started vomiting blood. I called the office and they took him to the hospital. So what does that mean? Yakoma okutegeera. So now after that, we look for someone who took him in the hospital. That one we do what we call collaboration. So which officer? When did the patron take this guy to the hospital? That statement is there as well on the witness statement. So you go to the OPO summary statement. Then you say this is corroborated by witness statement number this of OPO sum, where he stated that I called the officer and we got the patron and to the victim to the hospital. Okay. So you're adding up this story. Okay, okay. Then after, let's confirm. Okay, let's confirm. You confirm by two things. Okay, confirm by the postmortem report. Why? We want to show, to bring out the principle of causation, that this guy died because of the beatings. Okay, and then you finally confirm with the suspect's statement. Because yegenyini musiru yeteeka ku crime scene yandigambye ze baali basibidde eri Masaka n'ateekawo alibi. Or he states that by that day I was admitted, I was sick. Yes, sir. That's why we confirmed with two. Yes. You can't solely rely on the suspect. Yes. Okay. So, is the workshop hard? Okay. So now, after that, you make a conclusive conclusion. Okay. A conclusive conclusion that, okay, that I therefore find that there is sufficient evidence to sustain the proposed charges. So that means you have evaluated, you see whether, now let me show you. Okay. Okay. Sustain the proposed charges. Okay. So we've collaborated and confirmed. So you see, is evaluation of evidence hard. So you see how we've done. It is the same way they write the judgment in criminal. The same format, but the only thing that when you're gonna take some examination, yeah, you get it. But the same process you followed, it's the same process you follow. They will tell you to make a judgment. I told your colleagues, we were seated at the veranda there of the auditorium the day before they entered for the criminal paper. I told them, get a judgment of Justice Mubiru and go with it. They thought, hey, they reached the exam. they told them to write a judgment. If you had gone with a case, no okuwoma police super. Okay, and I think I've said that the poorly performed subjects are criminal and family this year. Criminal and family. The highly passed is civil. Civil is the highly passed in category A, followed by corporate and commercial. Sunny believe. Sunny believe. Okay. Hey. So, okay. So now, after that, what's hard with evaluation? And if you look at your books, it is where you write much. The rest, okay. But learning that art of evaluating evidence. Once you learn that, you are good to go. And probably that's what we're going to do in workshop for as well. I will not teach anything else. I will repeat evaluation of evidence until you can evaluate it yourself. Okay. So then let's go back to our learning outcomes. Then further ability of drafting committal documents. So which law talks about committal proceedings? Let's go to the TIA. Someone in the TIA. Okay. The presumption is you guys know how to draft a charge sheet. Okay, so let's go to section 22 of the TIA. Contents of the indictment. Section 22 of the trial on indictment. Okay, contents of. So before you say that, because I know you have a group that is going to draft the indictment. Rush up where you are you going to die? Okay, just know that person who's going to draft is going to draft something wrong. Where will come to? Okay, so what are you supposed to do? Come to section 22, you read the contents or you call it, then you check on it to see. Okay, are we together? Okay, if you want to see how it flows, okay, look at section 27. Okay, 27, 22 gives you just the contents. So when you go to 27, it gives you the form, how it is supposed to be drafted. Whenever you're doing any questioning and the document is under the law, don't use any other template. We're not going to go before. The right template is here in the law. Okay? All about the notes of motion, you end up doing something wrong. Criminal, the notes of motion in criminal that you guys are going to use, cancel for the week. It is in the rules here, but okay, we are going to get there. Okay, so the presumption is you read section 22 and section 27, you draft a right indictment. Okay, an indictment is the one that is used for committal, not the charge sheet. On committal proceedings, we don't read a charge sheet, we read an indictment. Katigojja kutuuka obagamba I read the charge sheet. Atozeeyo. You get it? Okay? So in the High Court, we don't use the charge sheet, we use the indictment. Okay? So that one, I think it will be okay. Okay? Yes? It is under section 27. Curricular 27, the indictment is, that is very clear. It says in the High Court of Uganda at Buganda Road, this and this, at this session held on this and this. You just go on filling in. Okay? That they can tell you, distinguish between filling and drafting. Drafting when it has no format. When it has a format, you do filling. So here you just fill in. This is a form. You get it? Bonocho chikola. Oja kofetite. Okay? So try it out. You will learn. Okay? So now the presumption is this person has been indicted, okay, and has been committed to High Court for trial. So once you are committed in the High Court, remember, in all capital offenses, once we indict you, we commit you. Once you go for committal, that's when you take plea. In all capital offenses, we don't take plea in the magistrate's court. We just go for committal and we saw. Have you been following the case of Uganda versus Muhammad Segiri and others? That massacre case. Okay, it started from the chief magistrate's court. Okay, they have not yet gone to High Court. They have not yet been committed. They are still on mention. They are still on mention. So until they are committed, the file is still under investigation. Once investigations are complete, they will indict them, then they take them to High Court. But that's why it doesn't go to the High Court. So work on it down, okay, until investigations are complete. So we can't grant them bail. Why? They are going to, they'll disorganize investigations. So counsel for that week, I'm giving you in advance. When if you are respondent, that is part of your submissions and your affidavit in reply. Those are things that should include. Okay. So we go on. So this person has been committed, is indicted, is in the High Court now. We are not going to look at plea. So the presumption is this person has taken plea. And which plea? A plea of not. Then you look at our last, okay, our next learning outcome. Develop the ability to draft documents for bail application. Then that takes us to application for bail in the High Court. Okay, you've understood how we've made the transition. So now we are on bail in the High Court. Before you go to the grounds and whatsoever, how do we apply for bail in the High Court? Which law? Which law? Okay.
Application.
Open the criminal procedure application rules. Criminal procedure application rules. It is the smallest act. The smallest act. It has one page.
That is what it is.
One page like this. Okay. Are we there? Hajjat, are you there? Okay. The criminal procedure application rules. So now, counsel for the week. On your notes of motion, whatever law we are citing should appear on your notes of motion brought under. You get it? Okay. So when you look at the criminal procedure application rules, okay. Okay, yes, the Judicature Criminal Procedure Application Rules. Look at Rule 2. It says, applications in criminal cases. All applications to the High Court in criminal cases shall usually be in writing and, where evidence is necessary, supported by. So what does that imply? It is a notice of motion supported by an affidavit. Okay. So that is the law. Okay. So now we want to understand. We've seen how we apply, but what grounds are we going to indicate in our application? Okay. What grounds are we going to indicate in our application? So that takes us to what we call grounds for granting bail in the High Court. Grounds for granting bail in the High Court. Yes, we are going for bail in the High Court. Okay. Yes. It's the Judicature Criminal Procedure Application Rules, Rule 2. Yes. Okay. So now, which section provides for bail in the High Court? Yes, Council Palawi. Huh? Presumption is what I see Zamda. Pressure command. Uh-huh. Uh-huh. Which section provides for bail in the High Court? Yes. Yes. Have we traced it? Hajat. Which law? Yes. Yes. Hajat, which law provides for bail in the High Court? Hmm? So, the first thing you appreciate, you have a right to apply for bail. Okay. Then after you knowing that you have a right to apply for bail, so ask yourself, okay, what grounds are you supposed to prove? Then we go to section 14, okay, of the TIA, okay. Now, you should be so keen, okay, to get up someone or some application for bail, okay. Kati basobola okuwa question nga bagrantinze bail, but on unfavorable conditions. When you have to apply for is revision. Okay, put that into consideration as well. So section 14 says that the High Court may at any stage in the proceedings release the accused person on bail, that is to say, on taking from him or her a recognizance consisting of a bond with or without sureties for such an amount as is reasonable in the circumstances of the case to appear before the court. Okay, so now they are, when you proceed to read the exact grounds, okay, because when you read section 15, it provides, 14 provides for the general things that we all know, but we have grounds that the High Court bases on, okay, that when you see them like this, you know, okay. Section 15, refusal to grant bail. It says, whenever you're reading the law, notwithstanding and subject to. Okay, so the rules of statutory interpretation will apply. That's why we first read section 14. It's there. But when you read 15, it says, notwithstanding section. What's the meaning of the word notwithstanding? That regardless of that, but don't consider that. For purposes of bail in the High Court, consider this. You get it? So the actual grounds that the High Court bases on, that's why they are called exceptional circumstances. Okay, so section 14 provides for a general grounds, but you should prove what's called exceptional. So we proceed. Notwithstanding section 14, the court may refuse to grant bail to a person accused of an offense specified in subsection 2. So the first thing, ask yourself, is it a bailable offense? So that means counsel for the applicant. One, or you should not have your fault off the fifth ground, okay? The paragraph, okay? That I have been informed by my lawyers of MSC for accompanied job that this is a bailable offense. Okay? So we want to see the offense we have. Is it excluded from the offenses that are supposed to be bailable? Ojja kugenda mukola application ngoli kanzo for the week. The offense is not bailable. Okay. Be article was mubadde mukola ki? Mugadde kola free kale muzitwale. Okay? So so we go on. So then you go to subsection 2. Subsection 2 says that an offense referred to in subsection 1 is, okay, 15, okay? An offense referred to in subsection 1 is an offense triable only by the High Court, okay? Only by the High Court, okay? So what does that mean? That offense court may or may not. It has that element of non-bailable. So that means murder is one of those offenses. Ask Katoka Jubi. Okay? Ask Katoka Jubi. That's why he wasn't granted bail. Okay? But now, the challenge we have a case that has set a bad precedent. Uganda versus Matthew Kiramu. Okay? That case, it is a murder case. Okay? This guy was granted bail. Imagine it was cash bail of how much? 50 million. Okay? The sureties, everyone, non-cash bail of 50 million. There were 5 sureties. After 2 days, the accused disappeared. And all the 5 came with 50 million and paid. And once you pay that bond, you are exonerated. The responsibility to look for the accused ceases. So once the accused disappeared after being given bail, these guys had to either be arrested or to pay 50 million each. So for them, they decide to come with the 50 million. They paid in court. And upon payment, you are exonerated from the obligation of the surety. So that's why they went off the hook and the accused is nowhere to be seen. Okay? You see, that is criminal law. We proceed. Okay? So, read that. So, you read those 2 cases interchangeably. Okay? You read the case, it is Katoka Jubi versus Uganda. His application for bail, I think it was Counsel Robert McKay appearing for state in that case. Get time. You read that case of Katoka Jubi from the first up to the end. You'll understand that you guys, you need Robert McKay as head criminal. During our year, he was head criminal, but yeah, the guy had contents. Okay? Yes. Then you read this one of Mukono, Uganda, it is Matthew Chirabo versus Uganda. Those are applications for bail. Okay? Then another offense of B, an offense under the Penal Code Act relating to terrorism. You read the application of Uganda, it is Jamil Mukulu versus Uganda. He applied for bail, but if he was not granted, why? It is anti-terrorism. So that means it is not a bailable offense. Okay? Then another offense, an offense under the Firearms Act. You remember the application of Robert Chagulanyi Sentamu versus Uganda, their lower case, was he granted bail until the DPP withdrew the charges. Okay? You also look at we have another one. Okay? Robert Chagulanyi Sentamu versus Uganda. It was an application for bail. The Arua case, they didn't grant him bail. Okay? The matter was just transferred to Fort Marshall. Yeah. And proceedings, okay. Then the one for Jamil Mukulu versus Uganda. Remember, he was charged with terrorism. Okay, so he was not granted bail on grounds that the offense is not a bailable offense. Okay, it is also under terrorism. It wasn't granted. Okay, at first, because it has the word made. Okay, they first refuse. Okay, no telegram line. Okay, then another offense we have the amend here. You read. Okay, then you have offenses under the anti-corruption. They are also not bailable offenses. You ask Kazinda, was he granted bail? Okay, you see? So it is Kazinda versus Uganda. Those are all bail applications. Then another offense, okay, it is an offense relating to treason. Okay, okay, it's also bail, but it's fun and corruption. Okay, offenses relating to treason. You read the case of Dr. Kanokiza Besigye versus Uganda. That's treason case. Okay, even the Chagulanyi, the same thing, because he had all the counts. Okay, so before you go, you say you're going to apply for bail. First, read this section. You see, is the offense a bailable offense or not? You will proceed in error. Okay, so now we go back to other grounds. Then we come back to our 15. Okay, they're saying that if he or she, okay, if he or she does not prove the satisfaction of what that exceptional circumstances exist justifying his or her release on bail. Okay, exceptional circumstances. So the question is, what amounts to exceptional circumstances? Okay, so you go to section 15, subsection 3. So counsel for the week, your application for bail. These are the paragraphs. Okay, genda ofune medical report from Ruzira ey'omuntu yenna okyuse otekemu particulars z'abantu bano. Okay, because you have to prove grave illness with a medical report from Ruzira or the facility where this person is detained. Bw'otagirete tebakuwa bail, ogenda lekayo kiraya nti mukaguli. Okay, so we go on. So section 15, subsection 3. Okay, yes, says that in this section, exceptional circumstances mean any of the following: A, grave illness certified by a medical officer of the prison. A, you read the application of Segirinya Muhammad and another versus Uganda. Okay, they are saying they are sick. Reason they will not get bail unless they get that certificate. Okay, that's the ground that courts have refused to grant them bail. that they have not proved that they are suffering from grave illness which cannot be handled by prisons. Okay. Yes. Then another one, a certificate of no objections by the Director of Public Prosecutions. Yeah. Okay. A certificate of no objection, the Director of Public Prosecutions. Okay. I'm not objecting to your bail. Yeah. Okay. Then another one, infants or advanced age. Infants or advanced age. Okay. Infants or advanced age. But the question is, okay, what amounts to advanced age? Yes. What? Cancer. What amounts to infants? Who amounts to an infant? Below 11 years. At what age does criminal be arraigned? Pharaoh. So, but when you read in the law of criminal, it is funny. Okay, their infancy is, I think, starts from 14 to Pharaoh. That's the infancy in criminal. Okay, because they start counting the age they're referring to here. Okay, and another thing, sometimes you may be detained when you have an infant. You get it? You are detained, but with an infant. So the infants here can apply in such circumstances. No, I myself, I made that application. Had a client, a baby, wa miezi musanvu. Nagenda kuza munana nagwereza mu prison. Namuga akali kanzije. Jaji yamugamba oyo omwana mukwate nga Katonda. Dayo omulabi ono buli kyamulya. Wasinga soyo, oba hitiwandibudde. Just infants of the baby, they must that the judge look at. Arrest in atunuli omukyala ng'omwana atandise okuzimba amatama, omanye empewo y'okumakishoni yagamba bugambe, your worship, no objection to the bail application since the child needs immediate medical attention, because Nyai said that the child is going to grow up with mental disorder. Okay, so that's how infants sometimes may apply. So you apply it accordingly. Okay, so but the question for advanced age remains the question of test. What amounts to advanced age? We have a case that defines advanced age. Okay, advanced age is 65 and above. Yes. Yeah, but yes. I also do flag upon with them. Okay. So now, okay. So now, I think, okay. Now, the last thing that we shall appreciate, this one has no law. Okay. If I happen to come across that authority, yes. Yeah, I'm saying that if I come, but that case says he's 65 years and above, advanced. But minimu gwoleta no gamba alimu advanced age. Ngagai mugumu na nawe otyamu. Okay. Remember, you see, regardless of this law, the section has the word mean. Okay? You may bring someone Gary 80. I don't know. There is something I saw. It was on news. I think it was one of these massacre things. This guy was charged of murder. Okay, so they took him to record a statement. So they detained him for like 2 weeks. So they had to make a search. So now was a okay, either stress yamusukako bwe yatuuka mu lujja n'agamba mukyala wange kulekedde wano endagaano yawe eri wano omwana wange omukulu omugambanga nti nakolanga guno omulimu era agukolanga. So the guy made a will ng'akimanyi sidda b'ofiisa abaali bamuwekedde baali nabo banafu bulungi nabo ne bagaaba because the whole society that they were listening to this person ng'akimanyi all the facts surrounding him wadde ayo takola ki kadda because yali akaddire kati nga bakusalira ogwa mmadda. Okay, balabalamu unless presidential pardon oyinza ovaayo ofudde. Okay,
They're saying at last age is 60 years.
60. Okay. 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 So when I looked at this museum, okay, then around 75 years. Nayenga alaba, all his hopes are shattered. Okay. You could apply for bail on that ground of advanced age. Because they can't bring you for a search. No time for college. Ente salanga namugabira abantu muzeeyi ne baba kanso gwamu essuuti. Okay, yes kanso. Muzeeyi yali mugezi nnyo. Muzeeyi yali mugezi yajja nga yakatuuka bw'atanayogera nga tebamubuuza kintu kyonna n'atandikirawo mukyala wange kati. Okay, so you see, me when I see something, I relate it to the law and I learn something. Okay, so when you look at the constitutional bail guidelines, but make use of this. That law has an amendment. Did you look at it? But it is soon coming out because bail. You remember that, okay? Bail is it was amended, but it's not yet just out, okay? Because now I've ever read it. The DPP is going to be given powers under the new bail guidelines, okay? Powers in bail application. Yes. Okay. So let's go on. So now, then after that, you also read the case of. You read the case of. It is Fred and Kapas. Okay, Kapas, Fred and another versus Uganda. Kapas. K-A-P-A-S-I. Kapas. Okay. Advanced age. Okay. So for them, in that case, they are arguing that it is 63. Okay. But when you read the guidelines, they say it starts from age 60, and so court has the discretion. But in most cases, court considers 65. Okay. So we don't have a 60 can dig. Okay. You attach your national ID currently. Okay. So now is criminal hard. Okay, so literally we've covered workshop 1. We've answered all the tasks. The only task remaining, role of the registrar. That one is not written under the law. Do you have any particular thing? Just for academic purposes. That one, that test requires you to take people through what we call organizing a criminal session. That's the role of the registrar. Okay. 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 In writing. So when they say writing, they pass the notes of motion. Okay. So now, so the role of the registrar is to organize a criminal session. That one is not under any law. Okay. So unless you have a clerk here who is well conversant with the process of, okay, but criminal sessions need someone from the High Court, basically. Okay, but I will conduct one whom I know that they have organized one in which, okay, in which there is a criminal session that's going to take place. So I'll contact the clerk who will give us the process. That's what we're supposed to write in there. So that marks the end of workshop 1, but we shall meet on Monday for workshop 2. Okay? Inshallah. So we thank Allah for having taken us through the past week and entered this week. So we pray for this endless blessings. Okay? So let me wish you the success of law. Okay?